So just doing some of the very basics before we dive into the content about criminal background screenings in a fair housing context. You want to do the next slide, Viola? I'm sure you all could recite this in your sleep, but just wanting to make sure that everyone knows that closed captioning is available. You can look for the icon down at the bottom of your screen. If you have questions or comments during the presentation, please feel free. We have everyone on mute right now, but please feel free to plop them in the chat box, and Viola will be keeping an eye out, and we will try to work those into the conversation. If Brandon wants to stop and do some sort of questions as we go, that's fine. Otherwise, we'll make sure that we have time reserved at the end to do questions. So just feel free to put them in there and we will help keep track of them. If you do also during discussion periods want to come off mic, if it's easier for you to do that, feel free to do that instead of using the chat box when it's time. And if you have any issues with Zoom or other tech stuff, you can either, if you are able to, you can chat Viola in the chat function. If you have questions about that, let us know. Or you're also welcome just to reach out via email. And we'll be keeping an eye on that too. It's sammateo@homebasecc.org, all one word, and we will try to help. So go ahead and do the next slide, if you please. So just some brief goals for today. We're going to be trying to do a lot, as we often do, in a relatively short period of time. But to start out with, we'll do a little bit of context building. Just sort of, we are increasing our shared understanding of the criminal legal system and the housing instability, and then the combination of those two and their impact in San Mateo County. We'll be talking a little bit about the purpose of criminal history screenings and their relationship to furthering programmatic goals. Just to make sure we're keeping it all focused on you and what your issues are. And then particularly Brandon will be just really deep diving into the current law governing the use of criminal histories in housing decisions and the ins and outs of that. So we'll do some big picture stuff and some nitty gritty stuff. So I'll go ahead and move on to the next slide and get us started with the sort of the bigger picture stuff. So at the very beginning, we thought it was important to just take a few minutes to talk through some national and then local context for this conversation, which is, again, just really about the intersection of the criminal legal system and housing more generally. So I want to just start out, if you want to do the next slide, please, just with a few sort of points to make about sort of when and how the impact of housing instability and the criminal legal system can come to bear to create the cycle that we often talk about, the cycle of homelessness, the cycle of the criminal legal system, and then how they intersect. So the first point I just wanted to share is that currently about 70% of people incarcerated in women's prisons throughout the country are mothers. And the number of mothers in prison increased really rapidly in the 90s from about 120 to increased about 122% from 1991 to 2007. So not only the vast majority of the people in women's prisons, mothers when they enter prison, but the majority of them are also the primary caretaker of their children in the home. So again, just thinking through the sort of the cycle and what creates instability and causes criminal legal system involvement. This is also not to say that it's only mothers. Based on a recent study of just self-reports, about 50% of people of men in men's prisons across the country identify as fathers, not including stepchildren. And again, that's self-reported, just folks who agreed to participate. So we can assume that it's probably a higher number. And in 2016, nearly 1.5 million children 17 or younger had a parent in custody, with about 10 million who had a parent who had been in custody at some point in their lives up until age 17. So again, when we're thinking about the destabilizing factors occurring in homes and things that lead to houselessness and housing instability, incarceration certainly plays a really large role. The next point is just one to sort of think about the impact of substandard housing, older housing that is not cared for on a regular basis. And we talk a lot about lead poisoning, and a lot of the community's home base works with, and I'm sure in San Mateo as well. But I thought it was really striking. This is from a study out of Rhode Island, really striking statistic that children who suffer from lead poisoning are 6 times more likely to become juvenile system involved. And of course, there are lots of factors that probably go into that, right? Not just the lead poisoning, but also, where lead poisoning occurs, the kinds of living environments where lead poisoning is most likely to happen. Again, housing that is older or not as well maintained. And then juvenile system involvement, of course, is one of the leading factors that will likely to result in adult incarceration. So just drawing that connection there. And then the last point, I think, to some extent speaks for itself, but just really flagging the impact of homelessness and housing instability and criminal legal system impact on young adults. So 1 in 10 young adults experience homelessness per year. And of those, nearly half of them have also been incarcerated. So just to sort of start us out thinking about these relationships before we move into talking about the particulars. Next slide, please. And along those lines, also just taking a couple moments to think about, again, the overlapping impacts of these. So formerly incarcerated community members are about 10 times more likely to experience homelessness than the general population. And then within that, BIPOC, Black, Indigenous, and other people of color and LGBTQI individuals are grossly disproportionate in the homelessness and criminal legal systems. And again, this is not unfamiliar information, but just thinking about, the Venn diagram of who is being impacted is really important when we're thinking about sort of the impact of criminal history screenings and the purpose of criminal history screenings and how we can use them most effectively and least harmfully. So big picture stuff, national information, and now just a couple slides on what this actually looks like to some extent in San Mateo. Next slide, please. Thank you. How did you know, Violet? I meant that slide. So as this is not news to any of you, but in San Mateo, there are very high costs of living and of housing and pretty low supply in housing, which results in significant housing instability for many, many people. So this chart here, this is from a UC Berkeley research study. This is a chart that has gentrification and displacement information in the Bay Area region. So displacement here is used to mean a neighborhood's loss of low-income households through eviction or other causes. And so you can see that San Mateo, even in the Bay Area, does experience a pretty high rate of gentrification and displacement by tract, both undergoing and advancing, and then also at risk of additional pretty high numbers of folks. And that also complicates investments, right? So if resources and investments are being directed towards these communities, but people are being pushed out, then they are not actually, there to benefit from those investments. Next slide, please. And just looking into this a little bit more kind of from a racial equity lens. So these are slightly dated numbers. I apologize for that. So these are 27 population estimates of the county. You can see that people identified as Black make up about 2.5% of the population in San Mateo. People identified as white are about 40.7. People identified as Hispanic, any race, are 26.1. And then the other groups are much smaller. But overall, including 25.6 identified as Asian, there's about 30.8% of people who don't fall into those first three categories. And there are all kinds of problems I recognize with the way this information is collected, but just I think the comparison will still be of use. And then if we go to the next slide, we can see the arrest numbers in San Mateo also by race for the same year. So this is arrests, this isn't convictions, this isn't law enforcement contact, this is just arrests. But if we compare to the overall population numbers, so Black people who made up 2.5% of the population overall in the county make up almost 7 times a higher percentage of the general are being arrested at almost 7 times higher rate. So for white people, it's a little bit lower. They're making up a little bit under. Their general population representation is 40.7, and it's more like 32 in terms of arrest. Hispanic is about 10% higher than the general population percentage. And then the reason I was sort of grouping folks in such a problematic way on the last slide is because of this arrest data is much smaller as well. So you can see that much like across this country, this is not unique to San Mateo, that people who are people of color, particularly Black people in San Mateo, are being arrested at least at a pretty disproportionate rate compared to their presence in the general population. And then on the next slide, just wanted to talk briefly. This is sort of a lot of content here, but again, I highlighted San Mateo just so you could sort of see numbers relative to some other neighboring counties. This is just to sort of give a feel for how many people are out of custody, but still navigating the impacts, the collateral consequences of prior incarceration. So this is 2019 data, but the 2019 population data you can see there. And they're relative to the size of the population, there are a fair number of jail bookings. So again, this is jail bookings going beyond arrest, but people who are actually being brought into jail is relatively high in San Mateo. And then the thing I really wanted to highlight for you all is actually the number of folks on probation. So again, relative to the population in the county, there's almost 6,000 people in 2019 on probation. So probation is usually folks who have been in jail locally and are now out under community supervision and are having to various conditions, restrictions on where they may be able to live, times of day, drugs and alcohol, stuff that I'm sure you're very familiar with. So it's actually a really high number of folks on probation. This doesn't include parole in the county. And then the last number there is revocations. And for those of you who aren't familiar, that's when people are on probation or parole and violate or found to have violated a condition of their release, and they are sent back to custody. So in this instance, people who are out on probation who are then sent back to jail. The majority, I don't know specifically for San Mateo, but the trend in the country is that the majority of people who are sent back on revocation are for technical violations. So not people who are committing new offenses or being convicted of committing new offenses, but people who do things like fail to report or move someplace they're not supposed to, or live with someone that they're not supposed to, things like that. So I just wanted to share those items about sort of the bigger picture impacts and how these systems can kind of relate, particularly around the number of people on probation, the revocation numbers. I think for housing providers and thinking about housing, just really understanding the scope in San Mateo of the number of people are having to navigate even post-release a whole series of conditions that really impact their ability to work, to find housing, to maintain housing, to reconnect with family, et cetera, and how that can all come to bear. So the last slide before I turn it over to Brennan for the meat of our presentation today is just to talk a little bit about the sort of why, right? Why use criminal history information? Why do we do this? And we've been talking actually to a lot of you. We're going to be doing some TA about this coming up as well. But some providers are just simply required to conduct criminal history screenings, either by MOU or by other contractual agreements. And the nature of some convictions, manufacturing of meth in public housing or a required registration on the 290 sex offender registry, certain people are mandatorily excluded from some types of housing because of HUD or other kind of funding requirements. But fundamentally, criminal history screenings are used because the people behind those policies dictating them are concerned about safety, right? Public safety, programmatic safety, personal safety, the safety of staff, of program participants, and are trying to use criminal history screenings as a tool to help, make an already really challenging job housing people in crisis a little bit safer and easier. And so the complicated piece of this, of course, is where it runs up against the realities that we know about who is arrested and who is convicted and how and why, and that it's not an equitable situation, and what public safety really, really means, what it is to keep people safe, and the important role that housing plays in true public safety. If people are unhoused, they are stabilized. If someone on the 290 registry can't find a place to live and is living under a bridge, it is hard to argue that public safety interests are being served. And that is not on you. This is a much larger problem, but it plays a big role in thinking through these policies. And then particularly when the tools that we have, things like running rap sheets or third-party criminal history screening tools, are frequently really flawed. Things show up on there that shouldn't be on there, arrests that didn't result in conviction, things that aren't supposed to be considered. And Brandon will tell you soon that there are things you can consider and things you can't. And so it can be really tricky to navigate all of this stuff. So ultimately, the truth is we cannot end homelessness in California without housing people who have criminal histories. And we don't further public safety by destabilizing and further marginalizing people who have been convicted of crimes. But like so many things that end up squarely on your laps, when your lap's already very full of all kinds of stuff, it is something that you all have to, think through and problem solve around, and certainly try to make sure that you're, not running afoul of the law as well. So I will absolutely stop there and thank you all again for being here. Please feel free to use the chat if you have questions or concerns. We'll be tracking them. And with that, I will go ahead and hand it over to Brandon. Thank you so much for being here.
Well, thank you, Lily. Appreciate the invitation, and thank you everyone this afternoon for joining us here for I think will be a lively and interesting conversation. So my name is Brandon Butler. I'm the Assistant Deputy Director of Education and Outreach for the California Department of Fair Employment and Housing. Now, that may be one of the longest, intros I can say exists in state government, but it is a pleasure to be here. And my background is that of a fair housing attorney. I started out actually working in Skid Row in Los Angeles for several years as a disability rights housing advocate. And then, have worked doing eviction defense for many years as an attorney, and then doing a fair housing practice. And so it's great to kind of be with my housing people. I was thinking about this presentation today and was, want to first kind of start by, lifting you up for all the work you do. It's such a critical position, and it's hard. And, I know I've been there. Been there in Skid Row, been there at the shelters. I know what it's like, and it's thankless sometimes, but you're really doing a really critical job. And I was thinking about when I started out working in Skid Row, I was maybe like 21, and I had a client who just had a stroke and had lost everything, was homeless, and was a musician, and I was a musician. We kind of bonded, and I remember kind of being there with him as he went from shelter to shelter for several months. And every day coming up on the train, I would call temporary shelters trying to get him in. And one day after several months, he did. But it was just a reminder of the challenge we have to house people. There was just me, one person, calling every day, trying to find a way to get someone into some temporary stable housing, and it was nearly impossible. So I know that the work you're doing is so important, and I know it's challenging. And we're going to talk about one of those challenges today, which is how do we house people who have a criminal history? What are the rules? What are the contours? What does the law say? So let me go ahead and share my screen, and let's kind of get into it. Let's see here, and just bear with me as I do my Zoom DJ here. Okay. All right. Let's go to slideshow. All right. So let's get into it. Let's talk about fair housing and criminal history, and then we'll have time to answer questions, and we'll have a grand old time. So first thing, just so everyone's clear, if you don't know, the Department of Fair Employment and Housing is California's civil rights agency. Okay, we're the largest state civil rights agency in the United States, and we work for you. We're here to help our housing providers, help victims of discrimination, but I hope you think of us as a resource, and that we work for you as your civil rights agency. Our mission is to protect the people of California from unlawful discrimination in employment, right? We handle all the employment discrimination, housing, which we're going to talk about today, discrimination at businesses, right? And from the perpetration of acts of hate, violence, and human trafficking. And unfortunately, I always want to come out and specifically say, the acts of bias-motivated violence against our AAPI communities in California is truly deplorable, and is also violates the civil laws we enforce. And so I want to let everyone know that we stand united with the AAPI community, but also that we're here to enforce the laws when folks are the victims of bias-motivated violence out in public. So just a little PSA on that. And again, our primary responsibilities are to do education and outreach, but really what we're known for is we investigate all the complaints of discrimination in the state for housing discrimination, right, or employment discrimination. And we also have a mediation division that tries to resolve these disputes, but ultimately, if we believe that there's a charge of discrimination that is meritorious, we will file a lawsuit in civil court against the housing provider. And just real quick, like the laws we enforce, today we're going to be talking about the Fair Employment and Housing Act. This is the source of law that governs our fair housing laws in California. So that's what we're going to be talking about. The Ralph Civil Rights Act we enforce, that's that bias motivated violence I was talking about. So that's the law that protects us there. The Unruh Civil Rights Act is also good to know because it's kind of our additional fair housing law. It's broader and it really applies to all businesses, right? You may be saying, well, I didn't know housing is a business. Well, most housing is a business as well. So we actually have two sources of fair housing law, and the Unruh Civil Rights Act is one of them, and it applies to all public places. So you can see how a shelter could fall under a couple different regards here. Disabled Persons Act, we're not going to be talking about that, but we enforce that. And then human trafficking, we help the survivors and victims of human trafficking. The civil side for forced labor, including sex trafficking. And then we also just kind of, this may be interesting too for you to know as in the shelter side, that we have a jurisdiction where there's discrimination among anyone receiving state funding. Right, so we have specific jurisdiction there under Government Code 11135. So that's our overview. Those are a kind of a portion of the civil rights laws we enforce. Now, I know Lily told me you've done some other fair housing training with our friends and stakeholders at Project Sentinel, so I'm not going to really get into the protected bases very much, but know that these are the protected bases in California. And let me just quickly lift up again, source of income is now unlawful in California, right? We can't say no Section 8. But I'm just going to share this to you because as you look at the protected bases, you'll see that nowhere does it say formerly convicted or formerly incarcerated, right? It's not a protected basis, right? So that's one thing I want you to think about. Say, how did we get here, and why is that an important point? Since we don't have a protected basis, how did we get here? So let's talk. We're going to get into that point. And then just briefly a little bit about our housing numbers. I'm sure I could come back and do a whole training on disability-based discrimination, right? Because that's the #1 level of discrimination we have in the state just about every year since I've gone back, I think in the last 12 years, it's been disability. And then before we get into criminal history, I just want to again talk about, we're going to mention this again, that we have some new regulations that help define our fair housing laws. And one of the things that's defined is kind of helping us understand, well, what is housing? And, it's kind of what you would think. It's a dwelling, it's an apartment, it's this and it's that. But I'm going to fast forward here and say, it's really too all shelters though. Right, sober living homes, transitional housing, supportive housing, homeless shelters, emergency shelters, domestic violence shelters, every type of shelter is. Why is that important? Because under our federal law, our federal fair housing law, that point's not entirely the same. Under our federal law, a fair housing law would require a great you have to live somewhere for a much longer time in order to acquire fair housing rights, but not in California. Right? Folks are in overnight shelter, we're covered under fair housing laws, right? So I just want to make sure we're all clear that everything we're talking about today applies to all of the various types of shelters in California, okay? And today I'm going to be talking about our Fair Employment and Housing regulations, right? We have the Fair Employment and Housing Act, which has a government code and helps define it, but I'm going to be talking about the regulations, which is we have an appointed body of lawyers who essentially write out and interpret what our laws mean in regulations. So that's what I'm going to be talking about today. What did our appointed body, the Fair Employment and Housing Council, what did they say when they talk about criminal history and housing? So this is like long form law, not just the kind of short form. And so these are new. All of this started in January 1st, 2020. Prior to this, we did not have this. There was no regulation. There was not a peep about criminal history from the Department of Fair Employment and Housing. But in 2020, and it got a little overshadowed, obviously, with the pandemic and everything that was going on. But here we are, and it's really important to understand that these are a source of help to you as a housing provider because they help interpret the law and give us explanations. Prior to this, we didn't have this. We had no idea. It was very unclear on many areas. So let's kind of get into what they are. And again, if you're trying to cite them or find them in the internet, you'll find it at 2CCR. California Code of Regulations, for example, 12005. So you can also find it at our website as well. All right. So kind of to pick up on Lily's point earlier, we're really talking about criminal history is really the intersection of race, the criminal justice system, and housing. When you mix it all together, we could get real deep on this point, from the point of we have a history in this country of intentional and purposeful racial discrimination, where we segregated communities based on race. And then once we did that, it was much easier to police them differently, right? And when we bring in overwhelming force in communities of color for a long period of time and convict and arrest folks for acts that maybe perhaps would not be someone would be arrested for and convicted of in a predominantly white neighborhood, we get disparate impact. We get disparate treatment of folks based on race, which then causes a disproportionality of being incarcerated, right? I mean, you can go around to any place in the United States and you see this carry out, whether it be in St. Louis, Missouri, California. You see that there is a disproportionate rate of incarceration and arrest and conviction of people of color, specifically Black people and the Latinx community. And because of that, right, which is a deep conversation, right? Because of that, if we have criminal records-based, barriers in housing, they're likely to have a disproportionate impact on, as HUD says, minority home seekers, right? That's why this is a fair housing issue and it's a race issue, because we're saying, hey, look, this thing that really wasn't about you, the housing provider, but was a part of our society that's been occurring for hundreds of years, has led to a disproportionate amount of people of color being arrested, convicted, and incarcerated. So now, if you're just trying to say, hey, I just want to have safety and run everyone's background, that's fine, but that may have a disproportionate impact on a distinct group of people. And that's why we're here today, because we now know that barriers to housing based on a criminal background history will have this disproportionality, will have this impact. So the question is, how do we have a background check that's not going to have this impact, or could lessen the impact, and will comply with fair housing laws, right? That's really what we're trying to do here today. Just 1 second. Put my noise canceling thing here on, so get real fancy. All right, here we go. So, and then Lily really brought a lot of great facts here, and I tried to kind of delete several of mine, but one of the ones that's important, I think, to remember too, is that we want to make sure that people are housed, have a fair chance at housing if they've been formerly incarcerated. Why? Because we know that each time a formerly incarcerated person moves after release from prison, there's an increase in the chance of rearrest, right? We need to stabilize people, right? Every time I talk about the right to employment if you've been formerly incarcerated, it's equally important to talk about the right to housing if you've been formerly incarcerated, right? It's difficult to move forward as a society if we have a preference for not renting to people or employing people who have a criminal history. We can't move forward. That's why these laws are so critical. So the first thing, though, the regulations talk about is they say, look, housing providers, there are rules on using criminal history information. So the first question is, well, what is criminal history information? What are we talking about when we say there's rules around criminal history information? Well, we're talking about any record that contains individually identifiable information, describes any aspect of an individual's criminal history or contacts with any law enforcement agency. Now, if you think about that, that's a lot. Any record, right? So the police officer walking into the lobby of the residential motel to say, guess what? I arrested Johnny the other day, and the housing provider says, oh, we better throw him out. We're using criminal history information, right? It's broad like that. It's not just always going to be what's called a background check. It's going to be these types of information and descriptions, right? It includes information describing individuals' arrests and subsequent dispositions, information that an individual's been charged or indicted for a felony, misdemeanor, or other criminal offense, right? It's all criminal history information. Information that someone has been questioned, right? Even just questioned by the police, apprehended, taken into custody or detained or held for investigation by law enforcement, police, military, etc. Whether or not the contact with law enforcement led to a criminal conviction. That's what I'm talking about. Hey, we picked up and brought in so-and-so from your building the other day. And we questioned them. We let them go, but we think they're probably dealing drugs. Landlord evicts them, right? We're using criminal history information, right? And this is off limits information, right? That we're going to talk about, right? But this is all criminal history information. There are rules on how we use it. Some can't be used at all, some can, and we're going to talk about that. But criminal history information also includes both records from any jurisdiction or records that have not been prepared strictly for law enforcement, right? So we're talking about like consumer reports, credit checks, credit records, right? Just your normal, I'm running a background check via a consumer report service. That's using criminal history information. And there are rules around how we use it. The next slide. So the first thing, now that we know what criminal history information is, well, what type of criminal history information is totally off limits, not allowed to use it? What are those? Well, arrests that did not lead to conviction, right? So this was a real big problem out in the East Coast, and I think, I don't know to the extent it has been here. On some level, it has, but it used to be, some housing providers were looking at arrests, and they'd run an arrest report, and they would exclude people from housing just based on an arrest that did not lead to a conviction. So there was no conviction, just someone was arrested. That is off limits information. So anytime anyone's been arrested, right, the fact that they were arrested is not going to be, it's going to be off limits information. Again, that same thing about information that someone has been questioned or apprehended or taken into custody, detained or held for investigation, that's off limits. We can't use it, even if the sheriff is telling us in the corner. Can't use it. Infractions, off limits. Someone gets a ticket for an infraction, it's off limits. Referral to or participation in a pre-trial or post-trial diversion program, right? Or a deferred entry of judgment program, unless it's offered by the applicant as mitigating information. So what we're talking about here is sometimes folks will get charged with a drug offense. And instead of getting a conviction for it, they agree to go in a drug court and diversion and all of this. And if they successfully do their classes, then the charge will be dismissed. And so what we're saying is that if someone's participating in one of these pre-trial or post-trial programs, that is off limits. Cannot look at that unless they say, hey, I want to show this as information of mitigating information for maybe there was another conviction and I want to talk about now I'm doing the right thing. So that's just a little caveat, unless they offer it. What else is off limits? Criminal convictions that have been sealed, dismissed, expunged, or otherwise rendered legally inoperative. Again, unless it's offered as mitigating information, right? So if it's been dismissed, we can't look at it. It's off limits. We can't say, oh, how did that get dismissed? And look into it. No, it's been dismissed. We can't look at it. Can't consider it. And then anything around juvenile court, right? Any matters processed in juvenile court are off limits. Again, unless it's offered by the applicant for housing as mitigating information. So these are what's off limits. So if we're running background checks, we can't look at this, right? Even if we're to mistakenly come up, can't consider it, right? Because these are what the rules of the road are in California. So that's off limits information now. Now that we've kind of talked about criminal history, what's off limits, I want to kind of get to the meat of like, how does this like why is this a fair housing violation? Let's talk about the theory of why a criminal history record ban that's too strict could be a violation of fair housing laws. And again, as we say in our regs, a housing provider's policy or practice regarding criminal history will violate California law when it has an unjustified discriminatory effect on members of a protected class, even when the provider has no intent to discriminate. Now, let me break that down. So what we're saying here is we're saying, look, even if the housing provider has the best intent, right? If the policy regulating criminal history has a unjustified, a strong discriminatory effect on a distinct group, it can violate our law. And we're going to talk about what are some of the things you can do to lessen this impact, to not have that unjustified discriminatory effect. We're going to talk about that. But as we said earlier, we're here because there's a theory in fair housing law called disparate impact, and I'm going to discriminatory effect, as we say in California. And why is this important? Because when we talk about discrimination, and I'll talk about it later, we usually think of intentional discrimination. I don't want to rent to you because of your race. I don't want you here because of your sexual orientation. Intent. But there's another theory that's basically like, there's no intent here. I'm just saying I don't want to have anyone in my shelter who's been convicted of blank sexual assault. I love everyone. I want everyone to live here. I just have this policy. Or I have a policy that says I don't want anyone to live here who's ever been convicted of a felony in the last 10 years. Okay, let's use my second example to broaden it out. right? I don't want anyone to live here who's ever been convicted of a felony in the last 10 years. Now, on its face, it doesn't say, I don't want any people of color to live here. It doesn't say that. But we know from what we've said earlier and what Lilia shared earlier, that even a policy such as that will have a distinct impact and will essentially be a way of discriminating against people of color when there may have been a way to achieve the same interests by the housing provider in a less discriminatory manner. So that's what we're talking about, right? Because any practice is going to have a discriminatory effect where it actually or predictably results in a disparate impact on a group of individuals, let's say Black people, Latinx community, or creates or increases or reinforces or perpetuates segregated housing patterns based on membership in one of those protected bases that we flashed you earlier. So that's the theory of law. I just want to break it down because that's what we're talking about. It's not that anyone's saying having a criminal background record is somehow inherently discriminatory, but it's based on the effects of our society, and the realities of our society will have a disproportionate impact. And the way it works, excuse me, in fair housing law is to show that something has a discriminatory effect. It's really a burden shifting test. And I don't want to get like deep into the weeds on it, but just understand that the way these cases come about, the way someone would challenge your housing practice would be to say, would have to be alleged that your policy is too strict. It goes too far. It somehow is having a distinct group, a distinct impact on a group of people, let's say Black people in my community, as I think even some of the data was shared in San Mateo. And then if the person complaining of discrimination, the complainant, can show that the challenge practice has a discriminatory effect, then the only way really the housing provider can prevail and avoid liability is by showing that your criminal history background practice is justified despite the discriminatory effect, right? So you can still have it, but it needs to be justified. Well, how do we explain if something's justified? Well, a business establishment, right? And there's a test for, a private business versus like a government entity. But a business establishment, let's say a private, nonprofit shelter, excuse me, can show that there is no violation of the act if there's a legally sufficient justification. And how do we show that? Well, we have to show that the practice is necessary to achieve our substantial legitimate interest, right? So our interest generally for all housing providers is going to be safety. We want to have safety of the residents, safety of the staff, and so that's why we're running a background check. And I think everyone, a very easily first prong here is going to say yes. That is a sufficient justification, right? We all want safety, so no one's going to, that's okay, and we all agree that's good. But the harder question is, does the practice effectively carry out your legitimate interest? Right? If I'm banning anyone who's ever been convicted of a felony, no matter when it was, does that achieve my interest of having a safe place? I don't know if it does. But those are the factors that happen. And then the third prong too is critical. Is there no feasible alternative practice that the housing provider could have done that would equally or better accomplish this interest of safety? Well, we could have asked people to submit mitigating information and tell us about what their conviction was, and then we could consider it, right? Just some of these things that you're probably already doing. But the reason you're doing them is because you're walking through these prongs of identifying how do we achieve our goal of safety with the lowest level of discriminatory impact, right? Because we want to follow fair housing laws, which I know everyone does, right? So this really brings us to the housing screening process. Right, so if a housing provider, meaning you, the shelter provider, does have a screening process, which includes reviewing criminal backgrounds, they can only deny housing if the applicant's specific crime is a demonstrable risk to other residents or the property based on objective evidence. Right, so this is how we create a housing policy that's going to be in line with not having that discriminatory impact, right, effect. So the first thing that a housing provider should consider is whether the criminal conviction is directly related. Okay, I want to talk about directly related for a second. So what is a directly related conviction? This means a criminal conviction, so if someone's been convicted, that has a direct and specific negative bearing on a substantial, legitimate, non-discriminatory interest or purpose of the housing provider, such as safety of other residents, the housing provider's employees, or the property. Now, I think, Lily and I talked about this, but often the question comes, well, isn't every, conviction somehow directly related? everything goes to fraud or truthfulness, or right. I mean, certainly there are those who try to do that, but I think the intent of the regulations is to really focus on a very kind of narrowly tailored and really finding the specificity of what was the conviction and how is it directly related to this issue of safety of, let's say, my employees, right? And I think you have to really, and I know you're probably getting technical assistance on this, but this is certainly not every conviction. It is certainly not. I mean, you're obviously would be looking at things as, you know, and we'll go through these other factors, but whether it was violent, whether it involved issues of safety, were other people hurt. You're looking at a lot of different factors, but I mean, I think that's our first question: is has to be specific. If someone's convicted of a check cashing fraud, it may not go to your issue of safety of other residents, right? So it needs to be kind of tied and closely related, right? And to just continue this forward, these other factors that need to be considered when we first are looking at this issue of our policy is, okay, was the criminal conviction directly related? Okay, check. That's my first check. Second, what was the nature and severity of the crime? Like I brought up check cashing fraud. Well, it wasn't probably too severe. No one was hurt, at least physically. These are questions you have to go through. What was it? What and because you're looking at the report. What was the conviction for? It was assault with a deadly weapon. Okay, that probably goes closer back to directly related, right? So you have to kind of go through this and not make kind of knee jerk of saying all of this is definitely a no. Let's go through what it was. And what's about the amount of time that has passed since the criminal conduct occurred? A lot of data suggests that once someone goes 6 years without reoffending, they reach the point of kind of the general population of having the same likelihood of reoffending, right? So that's a really important question. When was this? Was it last year? Was it 2 years ago? What happened? So these are the kind of the first initial sets we have to consider. Convictions need to be directly related if we're going to think about denying someone from housing. Nature and severity of the crime, and the amount of time that has passed. Kind of like a scale, right? The longer the time goes, the more it weighs in that it shouldn't be a way to keep someone out of housing. Nature and severity, more severe, right? It kind of you have to look at this individualized assessment essentially. And we talked about directly related, but and going back to this, and we already hit this slide, to show you a couple of directly related examples, right? A 10-year-old misdemeanor conviction for a driving offense would not likely be directly related to fulfilling the financial obligations of being a tenant, because there's no rational relationship between the violation and the identified business interest, right? Where we need that relationship between the violation and our business interests, right? You got to look at that. So that's one where it's likely not, right? Likely a no, as opposed to, excuse me, I'm just gonna water. Excuse me, a recent criminal conviction for residential arson could be directly related to the risk that an individual may injure other residents or property, because there is a rational relationship between recently committing residential arson and injuring residents or property. Now, this is an example we use in our regulations. And I think what's key about looking at it is the regulations are very clear to specify a recent conviction, right? That's what made it, you get someone recently convicted of arson, which goes to my interest of safety of other residents and the property. That's a directly related conviction for which I'm concerned. And if going through our other factors, it looks, residential arson is pretty severe, right? And where other, risk of injury, the severity of it, how much time has passed, not much. These are how the assessment would kind of look for at least identifying the directly related convictions that are going to be a concern and for which you may deny someone housing. This is the first part of it. Now, with that kind of idea of what a policy should be, that it's going to be one that's going to say you can live here subject to, we are going to exclude people who have these directly related convictions and we're going to look at the severity and the recency. That's your policy. But the policy should further have these factors. Now, doesn't necessarily mean under our regulations that you need to have every single factor. I would say the more factors, the better in terms of showing that you have a policy that has the lowest level of discriminatory impact. You've done everything you can do to lessen the impact because you know the history. So one is we want to make sure that we're focusing only on those directly related convictions. It should be narrowly tailored and focus on whether any criminal conviction is directly related. If it's not directly related, then we move on. So that's our first step. Second, does the screening policy of the housing provider provide an opportunity for the applicant to present individualized mitigating information, either in writing or in person, if the housing provider is concerned about an applicant's past conviction? Right? Is the policy just saying, hey, we're concerned, you can't live here? Or is it something saying we're concerned because we see a directly related conviction that was recent, but you have the opportunity to present any information you'd like to us about helping us understand why you would be able to still be a good tenant and lower our be in compliance with our business interests, right? Does it do that? Does the housing provider's policy provide written notice of the opportunity to all applicants to present mitigating information if a housing provider is concerned, right? Do we have that in writing, or is it something we only tell certain people, right? That's another factor that's good. It's a good thing. Another factor is, does the housing provider consider the factual accuracy of the criminal history information of the applicant? Meaning the background report does not contain outdated, incorrect, or falsified information or information that is erroneously attributed to the individual being considered, right? We see, as Lily was bringing it up, oftentimes, a criminal background check could have a lot of false information on there. It could have been identity theft. The court clerk could have written down the conviction wrong, that then gets reported out. There could be a lot of different things that happen of why it's wrong. And what I often hear from folks is, I wasn't convicted of that crime. Someone wrote it in wrong on the court reporter, on the computer, and it showed up as, blank felony when it should have been X felony, right? Which may have been not as severe. And so that's why it's important to let people know what the concern is and what the report said, because that gives them a chance to provide that information to say, hey, it's wrong. Here's this, here's that. Here's my parole agent. It's all wrong. So that's an important factor. And again, this goes to showing that your policy is more likely to be in compliance with fair housing laws when it does this. The other factor is, does it delay seeking the policy, considering, or using a third party's report of criminal history information until after an individual's financial and other qualifications are verified? Why is that important? Well, we want to give people a fair chance, right? Let's say someone passes every other qualification. They're great. You're excited. Now you do the background check. Someone's getting, the idea is more of a fair chance before being shut out at the beginning and said, you know what, we ran a background check before you can even apply. You can't come. This gives that person an opportunity to then show their mitigating information. So that's one factor. Does the policy provide a copy or description of the criminal history background check policy to an applicant upon request? I think I would just say you might as well just have it out there, right? Have it in the application. Here is our policy. Here's a description of what we're going to do. And again, a lot of this you can take right from the regulations. We're looking at directly related convictions, the severity, the recency. Does your policy consider mitigating information in determining whether to rent to an applicant with a past criminal conviction, right? And what's mitigating information? This is going to be like information whether the individual was a minor or a young adult at the time of the conduct upon which the criminal conviction is based. That's important, right? The amount of time that has passed since the date of the conviction. It was a long time ago, right? There were cases in the East Coast when HUD started to take this issue up, of people who are applying for senior housing who were convicted of a felony 40 years ago, 50 years ago, and they couldn't get senior housing. So that's a big important point. How long ago are we talking, right? Thirdly, evidence that the individual has maintained a good tenant history before and or after the conviction surrounding the criminal conduct or conduct after the conviction, right? So this is looking at, do they have a good tenant history? That's mitigating information that could overcome the concern around a directly related conviction, right? So this is all factors. It doesn't mean it's one or the other, but it's kind of like boiling the soup of what mitigation do we have, right? Additionally, evidence of rehabilitation, including a person's satisfactory compliance with all the terms and conditions of parole or probation. That's a mitigating factor. Successful completion of parole or probation, mandatory supervision, or post-release community service. A certificate of rehabilitation, right? This is something folks can apply to, which essentially shows they've been rehabilitated after their conviction. That counts as mitigation. Or other conduct demonstrating rehabilitation, such as maintenance of steady employment, et cetera, right? Lots of factors. So as your housing provider, you want to let folks give this to you so you can consider it. Now, another mitigation is whether the conduct arose from the individual's status as a survivor of domestic violence, sexual assault, dating violence, stalking, or comparable offense, right? Someone may have been convicted of a felony, but they were actually surviving domestic violence. And you want to consider that as that could be a mitigating factor when you see, assault, but you find out they were being brutalized in a domestic violence incident. And sometimes, as what happens, there could still be a charge against the survivor, right? So these are factors. Other factors are whether the conduct arose from the individual's disability or any risk related to such as conduct which can be sufficiently mitigated by reasonable accommodation. Now, let me stop on this point because this is an important point. While it's in the criminal history kind of field here, this is also kind of one of those ones that intersects with disability, right? Because you not only is that a mitigating factor, but you may have the situation just on disability. And I'll give you an example. There's a case out in the forget which court out East Coast, but basically the facts where someone was arrested for and convicted of lewd conduct. And what had happened is they were in their 20s and they had a mental health breakdown and they were walking around naked. And they were picked up by the police. They were arrested, charged, convicted for lewd conduct. And when the person went to apply for housing, said, hey, you had lewd conduct. This is like a sexual offense. You can't live here. And the person said, wait a minute. At the time I was convicted, it was due to my disability. I was having a mental health breakdown related to my disability. Here's the doctor's letter. Here's everything that happened. And I imagine if people just even think through the media, you've heard of these stories of people having a decompensation episode, something maybe severe could happen, even arrested. And now someone is saying, don't look at that. Give me a reasonable accommodation. Now I'm taking medication. That's not going to happen. Here's my doctor's letter. So this is just one of those intersections I flag. And I've actually done these cases where folks did have a conviction, but the reason was related to their mental health disability. And now they have been doing several steps where that's not the issue. They were duly diagnosed. They were using drugs. Now they're in sobriety, not using, and that was all related to some of that. So just pointing out that that's a kind of a big prong of mitigation. Now, kind of going to this next question of, well, okay, you get me on what we're talking about, kind of what are the factors, what we should be doing, but what about if you're just a housing provider saying, hey, look, I just use a third-party, company. I just send it to them and they give me a thumbs up, thumbs down, right? There are many. RentSafe does this. A lot of them do this. They just yes or no. So as we say here in our information, is that a housing provider may rely on a third party checks. Yes, you can do that. However, it is not a defense for a housing provider to have relied on a third party's criminal history report if the use of the criminal history violates our fair housing laws, such as third parties. So therefore, third parties are also subject to our fair housing laws. So, in this respect, it's unlawful for these credit reporting agencies to report records of an applicant's arrest, indictment, information, or misdemeanor complaint or conviction of a crime that is more than 7 years old from the date of disposition, release, or parole. So it keeps moving that date. So basically, it's like, look, you can use a third-party company, that's fine, but they can't look at the off-limits information. Can't be looking at arrest records, can't make decisions based on any of that, juvenile records, all of that. And then if you're using the credit reporting kind of, consumer reports, that's fine too, but know that it's unlawful for them to include information that's more than 7 years old of like someone's parole date. So those eventually do fall off, right? So someone shouldn't be looking past that. But if it doesn't and someone used it, that could be a violation, right? And again, this is different than a live scan check. So this is kind of my take on the policy side. I'm just going to quickly wrap up intentional discrimination, and then we can take questions. Does that sound good, Lily, in terms of time frame? So I'm sure you have lots of questions on policy, so we'll do that. But I just want to quickly say, when we talk about criminal history, it's important to remember, it's not just about having a policy that was just neutral but had this impact. There's also this issue of what if we're using this policy to intentionally discriminate, right? We are using it to intentionally discriminate against someone on the basis of a protected characteristic. So an example would be it's unlawful for a housing provider to use criminal history screenings to intentionally exclude individuals because of their race, right? Or only run criminal history screenings on certain racial groups, or treat individuals in different racial groups differently based on comparable history. Well, I'll let a Latinx person move in with blank offense, but not a black person with the same offense. That's intentional discrimination, right? So I just want to flag this, that we got to treat everyone the same with regard to our policy, right? We can't look at or only do things more because we believe falsely that there's a propensity for violence. So run it on these people or anything like this. That's all going to be intentional discrimination. Um, and one of the other issues that comes up is pretextual discrimination, right? Using a criminal background history check to tell someone, hey, we didn't rent you because of your criminal history, but the reality was I actually didn't want to rent to anyone who's Latinx. And what some of the ways we can show that is if someone didn't actually know someone's criminal history information at the time they told them that was the problem, right? That means it's a pretext, right? When you actually never ran the background, but you just wanted to tell someone. And I would see this when I would do a lot of testing when I ran a fair housing organization, where a black tenant would be told on a test. And if you don't know what a test is, this is where we send in like a prospective black tenant, prospective white tenant, who are both lying. They're not trying to live there, but we're just going to measure the differences. And one of the things you'd see consistently in a race test is a black applicant would be reminded by the housing provider that they would be running a background check, and they would not say that to the white tenant. It's a way possibly, and something you'd look to, is it pretextual? Why did you say that only to the black tenant? Were they going to be treated differently, right? So pretext and intentional discrimination still exist, even though generally we're just talking about policies where intent really isn't the issue. And then importantly too, is discriminatory statements. Housing providers cannot make any statement indicating a blanket ban on renting to anyone with a criminal record. You can't say, I'll never rent to anyone with a criminal record here. No felons allowed. That is a discriminatory statement. No felons, no criminals. Whether it's written or it's just orally stated, it's all a violation of our fair housing laws, right? So we can't do that. But it's not unlawful to advertise or state that you're going to run a lawful criminal history check, right? That's okay. So you can say we're going to run a criminal background check. Okay, it's going to be lawful. That's fine. But it doesn't come out and say no felons, no blanks. We can't do that. And then I just threw this in at the end. I don't really want to get deep into it, but I'll just kind of say it at the outset. There are some regulations that deal with like land use practices related to criminal history. And you may be saying, well, what's that? What are you talking about? Well, I mean, you may have been hearing in the news, and I think it's an important point, that many cities have enacted crime-free multifamily housing ordinances, right? Sometimes they're by law, sometimes they're encouraged by a local sheriff department. But basically they say, hey, landlord or anyone living in this area, you're now a part of our crime-free ordinance. And what it says is that if we come to the property 2 times, for a tenant who's calling us, or if a tenant's arrested, then they need to be evicted. They need to go based on just being arrested, right? So, this section is really about that. Practices requiring persons to use specified criminal history records, or prohibiting persons from renting based on specified criminal convictions, or mandating initiation of eviction proceedings against tenants and occupants arrested, suspected, or convicted of crime. So this isn't these are ordinances, but I'm just flagging the issue to you that if this could be a fair housing issue where there's an ordinance saying you must not rent to anyone, or you must evict someone or initiate proceedings where we have arrested them, right? We just said that information's off limits, and here we are with the policy saying go ahead and evict them. So I won't kind of dwell on this part, but I just wanted to flag the issue that this is something coming out more and more around what are cities and counties doing to perhaps they may have a law that may be saying certain people arrested are a nuisance and therefore they have to be evicted. So I'll kind of get it to move on past these questions, and I don't want to get like deep into this, but just know about that. And then lastly, I know many of you may be operating or will be operating in cities that have their own ordinance, like Oakland, right? And I believe other cities are looking at this. And just what this slide is just telling you that those laws will not be superseded by ours. The local jurisdiction may have their own protections, and that's okay. And nothing in our regulations exempts them from having that. So if you're in Oakland or a place like that, that is the law that you need to follow. And then, as Lily pointed out too, one of the ways that a housing provider can defend or show that there isn't as much of a discriminatory impact with their policy is if they're complying with a federal law or some type of a licensing requirement, right? So compliance with a specific federal or state law that apply to a particular transaction at issue and require consideration of criminal history information constitute an affirmative defense, right? So there is this defense too, right? Our regulations recognize that many of you may have to apply with a federal law, a state law that requires certain criminal history information to be looked at. That will be considered a defense. An example would be, right, the 42 USC 13663A, the ineligibility of dangerous sex offenders for admission to public housing, as well as if you've been convicted of manufacturing methamphetamines on federally assisted property. That will also be grounds for being ineligible from federal Section 8 voucher, right? So no Breaking Bad and still getting a Section 8 voucher. So those are defenses. So just pointing that out, the law recognizes that housing authorities aren't going to be sued for a violation by complying with this. And then last, I'll just point out that we launched just maybe last month a new portal where we're asking the public to send us reports of discriminatory applications or advertisements. Because we're finding a lot of folks don't want to go through the complaint process, but they want to let us know, hey, we found blank discriminatory ad. It said no felons here. And so we've launched this portal, and believe it or not, we've already received a lot of violations, and we're going to be continuing to monitor those. And we're doing enforcement actions or compliance letters for housing providers who violate it. And then we do have information on everything I've spoken about here today on our website, in our publications. We can try to chat that out today before we leave, but we have a fact sheet, which is really good for applicants to housing to look at. And then we have an FAQ, which is a little deeper. Perhaps the housing providers would like to see that. And then we have other information on your fair housing rights, but also I just wanted to highlight, we do have a poster that we've encouraged all shelters to put up. We've mailed them out to various shelters. I may have a few more left. If anyone wants them, I can try to send them out to you. But these are posters in multilingual formats that go over someone's rights to be free of discrimination and harassment in a shelter. And with that,
Brandon, I went ahead and added those resources to the chat.
Awesome.
And then in addition, our portal is also added to the chat. But then I'll at the top, you'll see a DFEH website. I'll send the resources page again. This will provide, in addition to the English links I've provided here, multi-language links, so that you can share those with anyone who might need them.
Thank you, Alex. I appreciate that. Now, and Alex is one of our trusty DFH staff members helping run the show here. So with that, let me get into any questions. I haven't looked at the chat. Lily, I don't know if you want to serve any up, or but more than happy to get into your specific questions or thoughts, or however I can be helpful.
Thank you so much, Brandon. That was, I was taking notes, and I've like looked at your slides twice in advance, and I was still taking notes. So thank you so much for that. A lot of really good information, and probably a lot to wrap minds around as well. So definitely feel free, if folks want to put questions into the chat or just pop off of and join us with your very real voice. You're also welcome to do that. I'm actually can go ahead and start with one question that I know had already been raised while people are kind of mulling. One question that I think was coming up for at least one provider that we were talking with is sort of how they should think about documenting and maintaining records having to do with criminal history information and the agency's screening decision-making process, in light of really wanting to make sure that they're documenting things and having things available. On the one hand, it sounded like the person we were talking with was thinking, I want to maintain these records. I want to keep them. I want to, just in case anyone has an issue or a question later on. But do you have any tips or insights on that? It's a little bit of a,
Sure.
minutia, but it's important.
Yeah, I mean, it's a great question. I mean, what I would probably, I'm not making a ruling or an opinion, but I think a good way to look at in terms of an example is what we've kind of created on the employment side of this question, right? Also on the employment discrimination side of our house, we have a law called the Fair Chance Act, and it regulates how an employer can, run criminal background checks while giving a chance for the employee or the applicant to, challenge or be made aware of their conviction and maybe perhaps get hired. And I think the way that comes is, things need to be in writing. as we point out, if you are going to deny someone housing based on violating your policy, they have that, recent conviction that's directly related and it goes to your interests. I think the best way to ensure that you're complying with law is that you're putting this in writing and you're apprising the individual of why you've made this. And I think that documentation of a communication that this is why we did it. The law doesn't say you have to, go through every contour and explain it, all the facets of it, but you're saying it was this conviction, this concerned us. It's in writing to you. And I'm also referencing our policy that you can provide mitigating information up to blank day. We will consider it. And after we consider it, we'll send you that second letter saying it's a no or it's a yes. And I think, just similar to our employment side in the documentation, it's having that in writing. So if someone says, hey, your policy is blank and you didn't follow it and you didn't give me time, you're able to say, no, we have it right here. We told someone there was a directly related conviction that we were concerned about that would make them ineligible of our policy. And we gave them time we told them what it was. We gave them a copy of the report we looked at. We gave them an opportunity to respond, essentially following the factors that I listed in the PowerPoint today. So I think that's the style. If you're concerned about like the kind of security of it or how that should be done, obviously it needs to be done confidentially as best you can, similar to a health record. We don't necessarily have guidance on that part of it, like how do we store it, what should it be? But I think if you're thinking about the fact that people can file complaints over this, right, and know that all someone has to say is, hey, it was blank shelter, they said no blank, and that may be totally false. And so you want to make sure that it's like, no, we had our policy of what it was, and then we give people an opportunity. So I really think if you're looking for guidance on like, how do we do this, I think you can look at our Fair Chance Act resources, which kind of give you an idea of what we've done there. And really it's about putting things in writing, explaining that people have an opportunity to present mitigating information, because all of those hit at the factors. So that way you're able to say, look, we're running our policy with the least impact we can. Right? Because we know there's going to be some impact, but as long as there's a substantial, there's a justification which you have and you're lessening it, you're trying to do it in the way that's least likely to have an impact. That's what's key. And I think that's really at the big level what the department's looking for is the idea that you're not banning people en masse, you're giving opportunities to be heard, you're giving a chance to present information. If it's still a no, then it may be a no, but there was that opportunity to be heard and had that fair chance and that shot. I think that's the critical component, not necessarily looking behind your analysis and saying, how could they not do it? It could happen, but I think going through the process will lead you to that right result. I think that's what's key about it.
Thank you. That's really helpful. And handy that there is a place that we can look to kind of go back and be like, all right, is it following this? Is it following this?
Yes.
Just again, want to encourage people. We will be doing TA on this, but Brandon won't be there and he knows more than we do. So ask your really hard questions, folks. And maybe one other one that has come up is, I think sort of as people are thinking through what feasible alternatives, what that means, what those look like. And similarly, what it means to really consider mitigation evidence. I'm sure that there's an emphasis on not just giving people an opportunity to spin their wheels by showing up and saying something that you're not really considering. So I don't know if you have any guidance or similar kind of tips on how to think about those two very distinct. I just grouped them together in one question, but
in terms of like mitigating, I'll take that side of it first. Like how should you consider the information? Look, I think a good idea is some type of time frame, right, to give people an opportunity to present it. And whatever it's likely, in my experience, likely what you're talking about are letters from parole agents, classes people have taken. It's going to be kind of a whole folder. Many folks are walking around with this folder already. They're being encouraged on the employment side to show you, look, I completed parole. Look, I did this class. I got a certificate in prison making blank. They're going to have all these things to show you. So, I think you actually want to consider, one of the things on the employment side we look at is if someone's turned in mitigating information and then there's a rejection letter the same day, it doesn't quite show us that it was even considered, or it was done earlier than the time frame, right? So I think consideration really just means like kind of it's plain sense of someone is looking at it, someone is reviewing it to determine whether that the information contained lessens that risk factor to your safety and justification angle. And I think that's really what it is giving it a fair shot. Again, when we think about what the directly related conviction was and what the mitigation is, it's like we're balancing. right? If it's a dangerous sexual offense, and there may be some mitigation, but it doesn't quite lower it to that point, then it still could be a no. So I mean, the housing provider still has plenty of opportunity to weigh this and come to the correct result. But I think what the takeaway from the regulations is that we don't want to ban people. We don't want to blanket ban folks. We want to give people a chance. Many folks are not going to present any mitigating information. They're just going to go away because there's a great stigma to having a conviction, and a lot of folks are just going to not even apply. We know that the research has shown that. But when you do let people know that we are going to consider this and there's an opportunity, a lot of folks may have a story to tell you. And so I think that's really the key, is just that you actually consider it, that you let people know you'll consider it. And I think from a risk adverse approach, like again, I'm sure everyone here is on that tip, which is we don't want to get in the fair housing lawsuit. We're trying to help people, right? We're not trying to discriminate. And I think the way you do that is you kind of go above and beyond, which is what the regulations I think really entail, is going through these factors. And again, if you're doing this, you're likely on the right side of this, and there really isn't going to be a big issue because you're doing these factors. Nowhere in the regs does it say, the department's going to review every decision you make and determine whether it was this factor and that factor. But the key is that we want you to have that framework that you're working through, because remember, prior to these regulations, people could just kind of do whatever they wanted and just say, hey, and a lot of people haven't updated from just where we were 2 years ago. 2 years ago, you could say, I don't want anyone here who's ever been convicted in the last 20 years or any felony. That's now changed. Even housing authorities they've changed. They're not looking back some past, even 2 or 3 years. Some are not even, very, very short look back periods, right? Because one, it's the concern that it's going to be too wide of a net, right? If you open it up many years, they're concerned about that. So they want to look at the mitigation, kind of lessen the impact. And what was the first part of your question? I went into mitigation and then I forgot the first part.
The
As soon as you
feasible
said it.
alternative idea.
Well, I mean, I think the feasible alternative idea is like one in the law of kind of, it's a broad concept that you could apply in any situation. Like for example, like in a familial status case where someone has a policy of not renting to families of 5 or more for a 3-bedroom apartment. The feasible alternative could be, well, maybe you do let them rent that apartment and maybe change the rates, right? So in criminal history, I think the alternative is, instead of banning everybody, right, or having this very strict policy, the alternative is really, we're going to look at these factors. We're going to do mitigation. We're going to look at directly related. So it's really that's the alternative. It's not necessarily that you're not doing a background check, but that the background check policy, there's an alternative way to do that, which is we're going to run it after we've qualified you first, right? You've made all of our qualifications, income or whatever, or need. Now we're running the background check. So really, I think the best roadmap for everyone is in our FAQ, and is what I've dictated here today is, those factors are very strong for lessening the impact. And if you're doing those factors, I mean, you're a model, and we salute you, because it's really important. It gives people a fair shot. And as I was telling Lily earlier, if you're running everyone through those factors and through this analysis, you're likely going to end up on the right result that you maybe even had often at the beginning, right? When we think of certain violent recent offenses that maybe, and things like that. If you run it through the analysis, so don't be afraid, well, hey, if I run it through this analysis, it's going to end up being all this. No, you're likely still going to get the same results. But what you're doing is you're making sure that folks who have a story to tell, who was that survivor of domestic violence, et cetera, have an opportunity to tell you. And I think that's a really key component, especially when we're talking about, I mean, really housing of last resort. This is really the end of, hopefully folks at the beginning and folks are rising up, but it's also for many folks, this is a difficult place to be. And how do we get people to, get housing and move forward? We need to make sure we have policies that are giving people a chance. And mitigation can be a lot of different things. So you want to even consider it in light of the circumstances. And again, lastly, I would just tell everyone, remember disability here. That's probably just as important when you're getting folks who are asking for you to, let me just say, in my practice, this would happen all of the time. Someone would be trying to apply for a permanent affordable housing, and they had a conviction, and it was related to their mental health disability. And we didn't have this law back then. We were using disability accommodation. they had a mental health disability, they were dual diagnosed. So just remember, all these things come together, and more than happy to anything we can do to help. If there's any additional questions you'd like us to address in a future FAQ or something, we're always open to hearing that. Any way we can make it easier for you. But right now, this is where it stands. And as I was saying earlier, this is one of those interesting things where if you read the government code, you're not going to see any of this here. This is only in our regulations that interpret it. So this is like kind of in the weeds. So that's why I'm happy you're here, because it's not something that would just like be intuitive to do. You would need to look at this. So that's the deal. So I'm really happy you're here, and I know it's so much hard work that you're doing, but we need it. And this is one step in the process to truly making an impact in housing. So my hat is off to you.
Thank you so much, Brandon. Does anyone else have any questions? Everyone is just reflecting, looking at their notes, being shy.
Blowing your mind.
Yeah, exactly.
It's Friday, 2:30. Yeah, I know. I'll also say, I don't know, Alex, if you're there, but we can also chat. We did a little video. If you haven't seen our video yet, it was a collaboration actually with the Corrections Department in California, CDCR. But we did a fair housing video on the kind of what are your fair housing rights when you get out of prison. It's just like a little 3-minute commercial that actually airs on Inmate TV. In all California state prisons, and it stars yours truly. So I'm more popular than Johnny Cash, as I say in the state prison. But yeah, check that out too. And if we have that resource, we'll try to chat it out to you, because I like to share that with applicants or people to kind of get an idea of what are your rights, and kind of a quick 3-minute segment. So if you want to hear like what did we officially say in a video, you can hear it in it. And let me just send it out to you right now, if it's hiding to you. But other than that, I thank you for your time. And here goes the link right here. It's our.
My apologies, Brandon. I didn't have that offhand.
I got it right here. Yeah, it's kind of, that's why I sent it, because it's kind of a little tricky to find. Here you go.
This is good. If anyone has to do like a report out on what they learned today, just simplify your life.
Yeah, no, share the video. It was really a fun project, and I've heard a lot of positive things from folks inside about getting hope that there's at least some rules of the road here, and it's not like, because everyone actually, when you talk to folks inside, like they all believe that it's totally legal to say they'll never rent to anyone no matter what, and that's what they're operating under. And even the parole agents, we're trying to re-educate the whole system to realize, like, wait a minute, we're all in this together. There's laws. So if you're running into a housing provider saying, no, don't send me anyone who's been convicted for anything, I don't care what it is, that we got to at least start there and start really working on this, because we have to kind of open up housing and not let it only be for only these housing providers are going to take folks formerly incarcerated in these communities, and then we're perpetuating and on and on and on. So but anyhow, I appreciate you. Have a wonderful weekend. Thank you so much, Lily. Thank you so much to Homebase for having us, and I hope we can come back and talk shop again soon. It's always a pleasure.
Thank you again very much, Brandon and Alex, for being here. And for all of you for showing up on a Friday afternoon to have your mind blown by all the FEHA talk. So we will be circulating, as we said, we'll be circulating slides and a recording of this. Please feel free to reach out to us at Homebase, San Mateo at homebaseccc.org about any questions you may have. And we are going to be doing some TA coming up as well. So if you think that there's somebody who wasn't able to make it today, who's thinking about these policies or needs to be thinking about these policies, go ahead and let them know to reach out to us. And we will be, just trying to help everyone work through on whatever level, if you want to workshop your policies, or if you want to just ask a whole bunch of questions that we didn't get to today. And again, looping people in who weren't able to make it. Bila just put our feedback survey up in the chat. We would really appreciate you just taking, I think it takes like 1 minute. We have it down to like a science for you all. So 1 more minute, and then you can have the other 8 back. And thank you again for being here today, and to HSA for getting us all here in the same virtual room.
Yeah, thank you.
And
take care, everyone.
Everybody.
Bye. Be safe, everybody.
Thank you so much.
Take care. Bye-bye.
Thanks.
Thank you.